Hello everyone, I'm just carrying on with my talk about misrepresentations. I got to the remedies for misrepresentations when the camera cut out because I'd used up the memory, but I've deleted a few things off now. Anyway, I was saying if there is misrepresentation, then a contract can be rescinded, and you can do this for any kind of misrepresentation. And remember, this is something that exists in equity. Therefore, it's up to the discretion of the judge whether they'll allow this or not. And there are certain obstacles to rescission. How about damages? Well, if the misrepresentation was fraudulent or indeed negligent, yes, damages are payable. Now, instead of rescission, you could get damages in lieu under Section 2.2 of the Misrepresentation Act, if the court considers that fair. And that's for again, negligent misrepresentation and indeed even innocent misrepresentation. So sometimes an indemnity is paid, and that's to cover the cost of any expenses incurred arising from the misrepresentation. That's more common if there was an innocent misrepresentation. Expenses are usually damages in the case of fraudulent or negligent misrepresentation. So anyway, if you want to rescind a contract, you must tell the other party you're doing so. And this was proved in Universal and Car Finance against Caldwell in 1965. But here are the bars to rescission. Third-party rights, as in Phillips and Brooks, 1919. It could be because how this would impact a third party that's not allowed. It would cause serious injustice to the third party. Another bar to rescission is affirmation, as in Long against Lloyd, 1958. So, as in you knew about the misrepresentation, but you decided to go ahead anyway. You can't return to that much later and say, "Ooh, misrepresentation. I decided to accept it, but now I decided I won't accept it." No. You made your choice. The next one is impossibility. Is in Clark and Dixon in 1858. It might be that things are impossible to reverse somehow. Number 4 would be the passage of time. If it's too long ago, like I said, Leaf against International Galleries. But this is a bit different from affirmation. Affirmation, you knew about that representation and decided to continue with it, say yes to the contract. Or Leaf and International Galleries, you didn't know about the misrepresentation contract going for a long time. It might be too late to stop. Okay, so the court will do what is just insofar as practicable. They have to consider the needs of justice, but also the realities of the situation. And that's as per Erlanger against New Sombrero Phosphate, 1878. So the measure of damages here is the same as it would be in the tort of deceit if it's a fraudulent misrepresentation. Look at Doyle and against Olby Ironmongers, 1969. So what has to be paid for is all the losses which aren't directly flowing from the contract. Those are the words used, directly flowing. Some things might be too remote. And the loss caused doesn't have to have been foreseeable. Even things which were unforeseeable when the person made the misrepresentation, those had to be paid for as well. Now, another important case about the damages for fraudulent misrepresentation is Newsmith Court against Scrimgeour Vickers, 1997. And this really proves that Doyle was indeed correct, that earlier case. So once a party has discovered that there was a fraud, then he must do what he can to keep the losses down. This is called mitigation. So he can't say, discover, oh, it's misrepresentation, or I'm going to carry on performing, even that increases the loss so much. No, you mustn't do that. So the damages can be counteracted by any benefit which the innocent party got as a result of misrepresentation. There might have been a misrepresentation, but it caused you even some gain. So you're not going to get very much in damages there. All right, as in the innocent party might have even gained from the misrepresentation. So what loss might there have been? Sometimes someone's missed out on a profit, as in East against Mora, 1991, or Clef Aquitaine against Laporte in 2000. Now, a defence that someone could try the misrepresentation is contributory negligence, but that's not held to operate in the case of fraudulent misrepresentation, and that was demonstrated in Standard Chartered Banking against Pakistan National Shipping, 2003. So, looking onto negligent misrepresentation, what damages can you get there? Well, under Section 2.1 of the Misrepresentation Act, it says they're the same as it were a fraudulent misrepresentation. Roy Scott Trust and Rogers in 1991 proves that. So the damages can be cut down if there was contributory negligence on the behalf of the innocent party. Remember, that's for negligent misrepresentation. In fraudulent misrepresentation, it would be different. If it was fraudulent misrepresentation, contributory negligence would not operate as an argument to reduce the damages. This is as per Gran Gelato against Richliff Group Limited, 1992. Section 2.2 of the Misrepresentation Act says a court may award rescission or damages in lieu of rescission. So Section 2.1 points out that the damages, any damages by Section 2.2 could be lowered because of the circumstances, because of a possible gain that the innocent party might even have made. Now, coming on to innocent misrepresentation. So Section 2.2 again said there are damages to be awarded in lieu of rescission. Now, an indemnity might be pertinent here. This is an equitable remedy, so again, it's at the discretion of the judge. Whittington against Seal Hay 1900 is a case of that. But bear in mind, in innocent misrepresentation, there's no automatic right to damages. It could be that there was no financial loss, in which case you might not get a penny. Okay, now let's think about negligent misstatement. So you're not allowed to rescind for negligent misstatement, but you can get damages as per the Wagon Mound. So can you exclude liability for misrepresentation? Well, the Misrepresentation Act, Section 3 covers this, and here's what it says. If a contract contains a term that would exclude or restrict A, any liability to which a party to a contract may be subject to by reason of any misrepresentation made by him before the contract was made, or B, any remedy available to another party to the contract by reason of such a misrepresentation, that party shall be of no effect except insofar as it satisfies the condition of reasonableness as stated in Section 11.1 of the Unfair Contract Terms Act 1977, and it is for those claiming that the term satisfies the requirement to show that it does. Close quotation. So, yes, you can restrict liability here, or indeed exclude liability, in as much as that's reasonable. Okay, it could be something like, I don't think it's fraudulent misrepresentation, I don't think that could ever be reasonable, even if you explicitly said in the contract, I am allowed to commit fraud against you. But if you said that negligent might be acceptable, innocent might be acceptable, or if I took some steps to verify what I said, and they weren't very exhaustive steps, that might still held to be reasonable if you'd put that in the contract or saying, well, we're going to limit my liability to pay a maximum of £1,000, even if I do commit negligent misrepresentation. And again, that might be reasonable, bearing about the amount of money in play. Even the losses caused the other party would say £3,000, 1,000 might have held to be a reasonable limitation of the damages payable. All right, so that is enough about misrepresentation. Toodaloo.